petitioners tried their best to convince 15 justices to declare the controversial anti-terrorism law unconstitutional. They remind the justices this is not a war between the petitioners and the government, but one colossal battle between the Constitution and an unjust law. Lawyer Shell Jokna says if the anti-terrorism law had existed in 1986, Cardinal Saint's call for people power would easily qualify as inciting to terrorism. He said by exhorting the people to gather at EDSA, Cardinal Saint incited them to engage in acts intended to cause extensive interference with critical infrastructure and to endanger people's lives. Jokno added anyone who tweets for people to attend a peaceful rally could be arrested for engaging in acts intended to endanger a person's life due to the danger of COVID-19. Justice Marvick Leone said he understood the fears of the petitioners because he himself experienced it when he was still a public interest lawyer. As an associate justice, however, Leone said they should be careful not to become a political department. They should not substitute their political wisdom with those who crafted the law. Leone also criticized the lack of an actual, clear case among the petitioners. He says it would be better to question the law at the lower courts where evidence can be received, not in the Supreme Court, which is not a trier of facts. The senior magistrate said the case of two Aitas being charged with terrorism may be an actual case. On the power of the Anti-Terrorism Council to tag terrorists, lawyer Evelyn Ursua says a person could be arrested, detained, prosecuted, and his assets frozen. She points out that these should be considered judicial actions. Justice Rosemary Carandang asked if the provision on delisting is not enough. Ursua answered that the process of delisting is only found in the implementing rules and regulations and the council can simply ignore it. Carandang asked the petitioners what would happen if the entire anti-terrorism law was junked. Lawyer John Mola said the Human Security Act would then be revived and the only thing that would be missing is Section 29, that is detention without judicial warrant of arrest. Speaking of the two Aitas, they went here to the Supreme Court to intervene in the petitions challenging the law. They're accused of killing a soldier in an alleged encounter, but their lawyers deny this, saying the evidence against their clients were just planted. Is this actual case that the petitioners are waiting for? The court decides next week if they will be allowed to join. Anjo Alimario, CNN Philippines.